Okay, hello everyone and welcome to the Essex Public International Law Speaker Series. So my name is Dr. Emily Jones and I am the co-convener along with my colleague and your chair for this evening, Dr. Megan Wong. It's my absolute pleasure to be your host this evening, so welcome to everybody who is joining us. And we're really pleased today to have with us Professor Lauri Mälksoo, who I will hand over to Dr. Wong to introduce shortly. But I briefly wanted to give you a kind of quick overview of the series itself, just so you have a sense of where this lecture sits within the kind of wider context of what Dr. Wong and I are doing. So the Essex Public International Law Lecture Series, as I said, is co-convened by myself and Dr. Megan Wong. We are both international lawyers, but Dr. Wong is a formalist and I am a critical international legal scholar. So we work across these two quite different perspectives and navigate quite different circles, but we both share a deep respect for one another's scholarship. And really the idea behind this series was to then bring these complementary perspectives and skills together. So the series really prides itself, therefore, on building on these two very important intellectual traditions of international law. We have formalism and international legal practice, and then critical international legal theory. So, as you may have seen, we have some amazing speakers lined up for you, including today's speaker, Professor Mälksoo. But we also have coming up next week, Dino Suvala, and then later on in the term, Lucia Solano, Professor Marty Koskinen, Judge Kitty Chassari, Professor Hilary Charlesworth, and Professor Campbell McLaughlin QC. So I'm now going to introduce you very briefly to Dr. Wong, who will be chairing our fantastic speaker this evening. So Dr. Wong is a lecturer at the University of Essex with myself and currently the director of the LLM in International Law. So the topic of today's lecture, International Law and Russia's 2020 constitutional amendments, falls very much within the expertise of Dr. Wong, who's a generalist international lawyer, but she's also particularly interested in and has advised states on the relationship between international and domestic law, and particularly on matters pertaining to treaty obligations. Dr. Wong has also published on canonical aspects of generalist public international law and is the author of a forthcoming monograph with Cambridge University Press entitled Responsibility of States and Individuals, Aggression at the International Criminal Court. She holds a PhD in international law from the University of Leiden and an LLM from UCL and was called to the bar of England and Wales. So Dr. Wong, over to you.
Thank you, Dr. Jones. First of all, good evening, good afternoon, good morning, wherever you are zooming in from. Thank you, Dr. Jones, for your kind introduction and for co-founding and co-convening this lecture series with me. I really enjoy working with you across teaching and research and now this. As Dr. Jones mentioned, this is our second lecture in our lecture series, which was inaugurated by Professor Niels Blocher 2 weeks ago on the occasion of the 75th anniversary of the first UN Security Council resolution adopted on January the 25th, 1946. In this lecture, Professor Lauri Mälksoo continues along this theme where he highlights noteworthy implications of the 2020 constitutional amendments for international law, where in this lecture, we feature his recent publication in the American Journal of International Law earlier this year, which I highly recommend that you read. To quote from Professor Mälksoo's publication, I quote, "Understanding these implications is especially important in light of Russia's status as a permanent member of the UN Security Council and as a country that has historically had adversarial relations with the United States." And here we see the connection with Professor Blocher's inaugural lecture that today in our lecture series, we zone in on the practice and the very topical current cutting edge developments of one of the members of the Security Council. But also for the comparative lawyers amongst us, in addition to the international lawyers and the EU lawyers here with us today, Professor Mälksoo's lecture also furthers the goal of increasing global awareness of international legal issues in a country which may be harder to access for linguistic or other reasons. And here today with the global power of Zoom, we can all virtually gather here to be with Professor Mälksoo in Estonia this evening. Now, let me tell you more about our distinguished speaker. Professor Mälksoo is a professor of international law at the University of Tartu. He is a member of the Institute. His monographs include Illegal Annexation and State Continuity, of which there will be a second revised edition forthcoming with Braille, something to look out for. His very well-known monograph, Russian Approaches to International Law, published with Oxford University Press. Together with Wolfgang Benedict, he co-edited Russia and the European Court of Human Rights, The Strasbourg Effect, published with Cambridge University Press. And also in the pipeline right now, he's currently the co-editor of the Oxford Handbook of International Law in Europe with Oxford University Press, together with 3 other co-editors. Professor Mälksoo has also published his work in numerous academic journals, including British Yearbook of International Law, American Journal of International Law, European Journal of International Law, Leiden Journal of International Law, Asian Journal of International Law, German Yearbook of International Law, and Baltic Yearbook of International Law, amongst many more. So truly a formidable scholar and a leading authority, it is my privilege to chair your lecture this evening, Professor Mälksoo. Before we proceed with our event, let me set up the housekeeping rules. Professor Mälksoo will speak for about 30 minutes, followed by a Q&A session. If you do not wish to be named in the Q&A session, please ask the question anonymously. I will otherwise read out your name, and if you would like your affiliations to be stated, please list that too. Also, please note that this session will be recorded, and again, I repeat, if you do not wish for your name to be in the recording, please do select to ask the question anonymously. And now let me hand over to Professor Mälksoo.
Thank you very much, Dr. Wong and Dr. Jones. I'm also very grateful to Essex University for including me to these series of lectures. And so today's topic is the international legal implications of the 2020 Russia's constitutional amendments. I think it falls in this area where this part of law that is often called foreign relations law and international law, where they meet, and where international law sometimes differs from what we read in textbooks, at least in Western textbooks. This diversity, this variety on the ground in non-Western powers, it is sometimes very interesting to follow and compare what is going on. So on 1st July last year, there was an all-Russian vote, or общероссийское голосование, on constitutional amendments. It was reported that the turnout of the vote was almost 68%, and that almost 78% of those who voted for those amendments, whereas slightly more than 21% were against. And the media at that time, they of course paid particular attention to the fact that these amendments, they enabled or authorized President Putin to stay in power for 2 more presidential terms, if he so, if he so wants and decides to run, which we don't know at the moment. And there are many things in these constitutional amendments that will be of interest from comparative constitutional law perspective or from political science perspective, but as advertised, the focus of this talk is more on those aspects that are somehow relevant from the viewpoint of international law. Still, about the procedure of those constitutional amendments, they had a bit of patchwork style, because the thresholds, the constitutional legal thresholds for changing Russia's constitutions, Chapter 1 and Chapter 2, are very high. So it was decided to only touch the chapters after these 2 mentioned chapters, but you have sometimes a little bit unusual outcomes. So, for instance, suddenly Article 67 prim has almost preamble-like qualities in its solemn declaration. So there are certain signs of how should I say, maybe speeding and trying to get it done in a way that maybe one wouldn't do if one would start to write a constitution from the beginning. So let's now come to those international law aspects, and I will start to create some tension from the ones that are probably less important, and I will end my analysis with the most important one. So in Article 67, there is a statement that any action directed at alienating parts of state territory, as well as calls to such action, will not be permitted. There are exceptions to this: delimitation, demarcation, and redemarcation of state state territory. And already in July, Russian State Duma adopted a new bill according to which activities violating the territorial integrity of the Russian Federation will be persecuted and punished as extremism. And in November, further legislation was adopted establishing criminal and administrative responsibility for the alienation of territory or calls to undertake it. If you move back in time, when the campaign in state media was undertaken to gather and generate support for the constitutional amendments, then in a noteworthy interview, President Putin highlighted this particular amendment, and he interpreted it from historical viewpoint. He pointed out that the Soviet constitutions, from his viewpoint, had a major flaw, namely Soviet republics could actually secede from the Union, which, as we know, happened in 91. And he said, in his interpretation, President Putin's interpretation, this constituted a slow impact mine from the perspective of the territorial integrity of the historical Russian Empire. Putin also added a further criticism that, in his view, some Soviet republics left in 91 not, and I quote, with what they came with, but took along with them historical Russian lands as well. So that is then a message here is that, yes, historically the Soviet Union allowed constitutionally secession. The Soviet Union allowed that, but today's Russian Federation no longer allows that from its territory, and even would punish that if someone would call for it. And I think this has, of course, practical implications for a neighboring country like Japan, for example, to which this constitutional amendment sends a clear message that further negotiations concerning the Kuril Islands, or Northern Territories, as the Japanese call them, will be futile. And in fact, the former Prime Minister Medvedev already said that in an interview, that we can do it. We can do it constitutionally. And here is also something we could see historically, in the early 20th century, when Bolsheviks did come to power, then at least in words, they were quite progressive in terms of supporting the right of peoples to self-determination. They had their own understanding of it, but nevertheless, rhetorically, they supported it. And as Putin correctly pointed out, this was even anchored in Soviet constitutions, that Soviet republics in principle could secede. I mean, in the end of the 80s, it turned out that it was not meant really like that initially, but it existed in formal law. And I think we can conclude that Russia has now evolved from a strong rhetorical supporter of the right of peoples to self-determination during most of the Soviet period to a skeptic of that right, at least if used against Russia's own territorial integrity. And there are of course paradoxes here, because Moscow used precisely the argument of self-determination for justifying the annexation of Crimea. But overall, we can expect Russia to use in its, let's say, international legal policies that highlight the importance of sovereignty and state integrity. As I said, the constitutional changes have a slightly patchwork style, but in a few other places one can find more stipulations that are indicative of Russia's foreign policy international law thinking. So the new Article 79 Prim stipulates that Russia undertakes measures for the support and strengthening for ensuring peaceful coexistence of states and peoples, for non-permissiveness of intervention in the internal affairs of the state. So who has studied the history of international law knows that especially this peaceful coexistence was a Soviet trope. This was something that, especially since the Khrushchev era, that the Soviet Union highlighted a lot, but part of it is also, especially if mentioned together with the non-permissiveness of intervention, is this Russia's criticism that the West has perhaps too much used the principles of democracy and human rights for reforming international law, for trying to reform international law without everyone's consent. So in that context, in the context of the history of the 20th century, the Soviet Union, peaceful coexistence, non-permissiveness of intervention mean exactly that, you know, the Western definition of the importance of democracy and human rights is not binding to other countries. Okay, next point is the new Article 67 Prim paragraph 1. And it says that the Russian Federation is the state successor of the USSR on its territory, and also state successor, in parentheses, continuator of the USSR in terms of membership in international organizations and their organs, membership in international treaties, and so on. So what does this mean? This norm is puzzling because it mentions two concepts at once, almost as synonyms. These are the state succession, or in Russian, право преемства, and state continuity, право продолжательства. Now, if you open any serious textbook on international law, for example, in English, among English language textbooks, let's say Brownlee Crawford, then there is a long discussion about how these concepts differ, how they mean different things. State succession means that the previous state comes to end, and then certain rights and obligations may be inherited, usually are inherited, but not necessarily all of them. Whereas state continuity means the continuity of the previous state, also notwithstanding the historical turmoil that has happened. And the interesting thing is that usually it is understood in the literature that you have to choose. You are either one or the other. Either you are state successor of the Soviet Union, like Kazakhstan on its territory would in certain aspects be a state successor of the Soviet Union, or you are really, you know, you continue the previous existence. And in 1991, it was, of course, in Russia's interest to highlight state continuity with the Soviet Union, because on this depended, for instance, the veto power, the membership right as permanent member in the UN Security Council, assuring control over, you know, nuclear weapons, certain assets, and so on and so forth. But once these things were figured out, settled out in the early 90s, Russia also learned that there was there were some negative sides to being the state continuator of the Soviet Union, namely when some of the neighboring states, former Soviet republics, former Warsaw Pact members, also accused the Soviet Union of certain crimes, certain deals, certain internationally wrongful acts, and then as if Russia would be then responsible for that. And Moscow did not really want that responsibility, was not ready for it. And that's why, although from the viewpoint of legal purism, you know, to say in one breath that one is state successor and state continuator, it doesn't really make sense if you follow the doctrine. But it makes sense from practical politics in a sense that it enables Russia to pick and choose in that context, and with what kind of heritage or legacy of the Soviet Union to be associated with, and in that sense it is also relevant for Russia's neighboring states that they can count on Russia taking what it sees as the positive aspects of the Soviet legacy, the strength, the glory, the victory in World War II, but it's not probably willing to discuss yet at this historical stage the less pleasant sides of the Soviet history with neighboring states. But you could still ask, why was it necessary to write it down in those constitutional amendments in 2020? I mean, it was not said in the Russian Constitution of 1993, to which those amendments now have been made, that Russia is a state successor or continuator. And one aspect of it is a development that happened in the Russian Constitutional Court, namely in a case on 10 December 2019, a judge, Konstantin Aranovsky, added a separate opinion in which he challenged the idea that Russia was a state successor of the USSR in the context of responsibility for Soviet violations of constitutional rights. And Judge Aranovsky, in that opinion, pointed out that the Russian government should not take upon itself all the guilt for Soviet crimes, since they were perpetrated by a different regime, and some of the acts were, in his words, he writes it directly, so even terrorist, he says. And that caused a bit of a turmoil in Russian media and political circles. So in my interpretation, at least one goal of this amendment is to assure that the view identifying oneself with perceived positive aspects of the USSR will not be snatched from the population, whatever, quote, dissidents, unquote, like Aranovsky might claim. So in that sense, this puzzling use of the dual use of state succession and state continuity as sort of synonyms, which again is wrong from international legal doctrine viewpoint, it has primarily an intended domestic audience still, which also is really normal and legitimate with constitutions, because I think all constitutions are first of all written to the people who forms this state. So it's not written to please the others. There are some other aspects that are connected with this somewhat defensive stance about sovereignty. One of them is the amended Article 67 prim, paragraph 3, which declares that Russia honors the memory of the defenders of the fatherland and ensures defense of the historical truth. Diminishing the significance of the heroism of the people in defense of the fatherland will not be permitted. And again, there is a context to it. So for instance, Russia and the Baltic states, as well as Poland, they disagree on the significance of the secret protocols of the Molotov-Ribbentrop Pact from August 1939 and what role this pact played in the outbreak of World War II and destruction of Poland, later on the annexation of the Baltic republics. So it representing, let's say, a view that for instance, puts very much emphasis on this Molotov-Ribbentrop Pact, may very well have, within Russia at least, have also criminal consequences for people rash enough to say so. But there are also other contexts. So, for instance, already in March last year, an amendment was introduced to the Russian Criminal Code in response to the removal of the statue of the Soviet World War II Marshal Ivan Konev. And now the new article in the Criminal Code makes it punishable offense to damage war graves, monuments, memorial plaques, but quite interestingly, also from international law viewpoint, and whether such places are located within or outside of the Russian Federation, so extraterritorial jurisdiction. So I mentioned before that I move from from things that are surely interesting and important from legal international law viewpoint to what is still the most important one, and that is the new Article 79, which in its second sentence says that decisions of interstate bodies adopted on the basis of provisions of international treaties of the Russian Federation were construed in a manner contrary to the Constitution of the Russian Federation shall not be subject to enforcement in Russia. And this is a significant specification of the Constitution of '93, which stipulates in Article 15, paragraph 4, that if an international treaty or agreement of Russia establishes other rules than those envisaged by Russian law, the rules of the international agreement shall be applied. So thus there is now a clear distinction between the Constitution itself and other domestic laws of Russia. And in cases of conflict between different norms, international treaties continue to rank higher than the Russian laws below the Constitution, but the Constitution itself is recognized as ranking higher than norms in international treaties or as interpreted by interstate bodies. And I know that a number of you have followed these developments for some years, and you know very well that this is not entirely new, because essentially the Russian Constitutional Court and the State Duma, they established the same principle already in 2015. But nevertheless, I would argue that this enshrining it in the Constitution is important because, well, it raises it on the constitutional level. And also, this is already the modified Constitution, the one that was amended in 2020, that operates as the yardstick for measuring the compatibility of judgments, for example, of the European Court of Human Rights. So, for instance, one of the amendments is also in Article 72G1, which specifies that marriage is an institution between a man and a woman. And this is also, well, relevant and important in the context of the future and current case law of the European Court of Human Rights. There is another article that is sort of related in its significance to this Article 79 that I just mentioned, and this is in Article 125, paragraph 5.1b, which specifies the competences of the Constitutional Court. And according to this article, the Constitutional Court may decide on the possibility of implementing decisions of a foreign or international interstate court, foreign or international arbitration court, putting obligations on the Russian Federation in case such a decision contradicts with the foundations of public legal order of the Russian Federation. So here, a further possibility is opened not to implement a decision or judgment based on international legal obligations, not only, based on the Constitution, but more broadly with the foundations of public legal order. And actually, in I think it was on 26 December last year, when the Constitutional Court already used that in the case of the UCOS arbitration case, and used this argument saying that Russia does not need to enforce or recognize it for various reasons, for which I don't now have time to tell you in detail. So there is a conflict here because Article 46 of the European Convention on Human Rights stipulates that the parties undertake to abide by the final judgment of the court in any case to which they are parties. And this can be, of course, understood as an obligation to accept the court's judgment, simply accept them, notwithstanding any reservations based on constitutional law or something like that. And this criticism was made by the European Commission for Democracy through Law, or the Venice Commission, which is, as you know, advisory body of the Council of Europe. Last June, they adopted an opinion focusing in particular on this Russian constitutional amendment, and they basically, said that they were alarmed about it and that Russia should not adopt it because it's not in correspondence with the spirit of the European Convention on Human Rights. But of course, the amendments were adopted nevertheless. So now much will depend on how other member states react to Russia's new constitutional approach. If they tacitly accept the amendment and its further interpretations by the Constitutional Court, then Russia will have succeeded in effectively establishing a constitutional veto power over certain judgments of the European Court of Human Rights. However, it could also trigger consensus among the Council of Europe that Russia cannot continue as a member with this kind of pick and choose enforcement policy if it indeed is going to use it. And it's interesting because usually it is assumed that human rights treaty obligations, they are not really based on reciprocity, but actually we will soon see in the context of world's most far-reaching human rights system whether this will always be the case, because it is also tempting to some extent, at least for some other states, or maybe tempting to follow the same lead. If Russia is not the only country for whom constitutional identity is important, so others can pick it up as well, and in that sense it can be a contagious policy. So to sum it up, for me this new hierarchy, highlighting the hierarchy of legal norms, highlighting the primacy of the Russian constitution, together with these competences that are given to the Constitutional Court in defending public legal order, it reminds me of this gun in the imagery of the Russian playwright Anton Chekhov. And Chekhov said that if a dramatist has hung a gun on the wall on stage, then in the following act, it will have to be fired. And the gun was there already, was put there already 2015. So now with the 2020 constitutional amendment, it was put on simply on a more prominent place, on a juridical stage. And at least my guess would be that the gun is there to be used. It is not there for decorative purposes only. So taken together, these Russia's 2020 constitutional amendments seem like a requiem to an optimistic liberal understanding on the role of international law that prevailed when the constitution was adopted in 93. And it seems to correspond with the current zeitgeist among great powers in which national interest trumps international cooperation and demands for state sovereignty over such international legal obligations that have started to appear burdensome. And all this, in my view at least, makes the basic norms of the Vienna Convention on the Law of Treaties, Pacta sunt servanda, and the rule precluding a state from invoking its internal law as a justification for its failure to perform a treaty appear weaker in the practice. And in a certain sense, this new Russian approach is also an invitation to reinterpret, at least in practice, how the European human rights system and the European Court of Human Rights must work. So to sum up, the key word of those constitutional changes that Russia adopted in 2020 really is state sovereignty in its different manifestations, whether it's territory or whether it's control over what do international legal obligations mean. And I guess in that sense, Russia has managed to bring across this point that state sovereignty, at least for many states and some very influential states like Russia, continues to be the central norm in international law. So I thank you, and I look forward to your comments and questions.
This brings us to the end of our session. Thank you for your attention, and thank you for the participation. And to Professor Mälksoo, thank you very much for joining us all the way from Estonia today and sharing with us your very excellent and recent scholarship in the American Journal of International Law. It's been a real pleasure to chair you this evening. Thank you again. And Dr. Jones, if you would like to.
Yeah, I mean, just thank you very much for that interesting talk. And just to remind our audience that we have another speaker next week at 11 a.m. GMT. We'll have Dina Subala speaking on capitalism as civilization. So some interesting crossovers and some differences there as well. But thank you very much, Professor Mälksoo. That was a really fascinating talk. And thank you everyone for coming.
Thank you for me as well.